Hi, this is Ed Sullivan and Marco Berti continuing our Retaliation series. Mark, a lot of times a company wants to fire an employee. The employee is not good. There's lots of reasons to document and to support the termination, but the employee is also engaged in protected activity that would otherwise be protected by Title VII. How does this impact the decision tree process of employers?
Well, you really got to scrub those out and with qualified, board-certified labor and employment counsel. And if you don't, what you would think was a no-brainer termination decision may not be. And there's some cases in some of the materials we have that illustrate that in a real extreme way. One of them is from the Seventh Circuit just this year, where an employee who came back to work after making some ADA complaints looked at the HR manager that he didn't think was doing enough and said, "I've never wanted to hit a woman before, but that one right there, I'd like to knock out her teeth." They fired the employee for violating their threats of violence in the workplace. Lo and behold, the Seventh Circuit said there was a fact question of whether really that was just a ruse, a pretext by the company to fire him for his protected activity of seeking an accommodation under the ADA. Another one, the employee told her psychologist she was wanting to kill her supervisor. Psychologist told the supervisor, and in that case, the post office fired her, saying, "You violated our threats of violence in the workplace." Again, the Court of Appeals said, no, you could find that there was a fact issue on retaliation because some other folks that had held a knife to somebody's throat were suspended but not terminated. And then finally, from the Fifth Circuit, there's a case where the lady was on a performance improvement plan. At the time she filed her charge, she didn't make the performance improvement plan, so they fired her like was threatened when they put her on it, yet and still a jury verdict in her favor affirmed by the Fifth Circuit. Unique fact patterns all, but the common theme is when there's been protected activity by the employee in the recent past, before you pull the trigger on termination, you really want to scrub it out with qualified counsel. Otherwise, you could land in the same trap that these employers did.